mode.
Good morning, everybody. My name is Oliver Judd. I'm the Executive Director of NECA New South Wales and ACT. By clicking on the icon-shaped hand, you can raise a question throughout the presentation, and we'll unmute your microphone and you can ask the question live. Or alternatively, you can ask questions by clicking in the box on the right-hand side. I'll pass you on to Gordon, who will now introduce you to the Fair Work Act and the review changes for 2013.
Thanks, Oliver. Good morning, everyone, and thank you for attending this webinar on the 2013 amendments to the Fair Work Act 2009. That is the amendments that were passed by the Parliament in 2013. Now, this morning we'll be dealing with the following topics, which is background to the changes, just a brief history on how those changes came about and the reasons for them, changes that commenced on the 1st of January 2013, which are already in effect, other changes commenced on the 1st of July 2013, colloquially known as the family-friendly provisions, and then further changes, perhaps some controversial changes, will commence on the 1st of January 2014. I'll also deal with changes to modern awards at the conclusion of the presentation. There will be time for questions at the end of the presentation if you would prefer to keep your questions till then, or if you would like to ask them, in the way that Oliver indicated during the presentation, then by all means please do so. Just turning to the background to the changes, the Australian Fair Work Act, as I'm sure you all know, was introduced to Federal Parliament in 2009, and it commenced on the 1st of January 2010. As part of that process, a number of standards were introduced, known as the National Employment Standards. Modern awards were dealt with, and the rights and responsibilities of employees and employers were to some extent clarified. The Fair Work Act, due to arrangements made with the states, now applies to all employers and employees in the states, and including New South Wales, except state government and local government employees. When the Act was introduced, the federal government committed to a full review within 2 years, and the Fair Work Review Panel report was released in June 2012. The panel, by and large, found that the Act is operating as intended and in accordance with the objects of the legislation. The government passed the Amending Act, implementing 17 of the 53 recommendations made by the panel, and as it says there, the first tranche of the changes commenced on the 1st of January 2013. So really the changes to the Act have occurred and will occur in 3 stages. Just going to those changes that occurred from the 1st of January 2013, I'll deal with them under a number of headings. The first heading being unfair dismissal and general protections laws, or general protections claims, also known as adverse action claims. The first significant change is that in both instances, that is an employee making an unfair dismissal claim, or an employee or other worker making a general protections or adverse action claim, now has 21 days from the date of the termination or the breach, as the case may be, to lodge the application. Previously, an unfair dismissal application had to be lodged within 14 days, and a general protections claim had to be lodged within 60 days. The reason that those time periods now coincide was to, among other things, prevent applicants from starting an unfair dismissal claim, withdrawing it, and then starting a general protections or adverse action claim a bit later. Now the applicant really has to choose which of those avenues they're going to pursue, that is unfair dismissal or general protections. The Fair Work Commission is generally very, very strict on the time limits, even though it's a discretionary time limit, that is that the Fair Work Commission can extend the time to lodge an application in either case. They are usually quite reluctant to do so and will only do so if the applicant can show exceptional circumstances. Also, a new change is that the Fair Work Commission, FWC, has discretion to dismiss an application where the applicant failed to attend a conference, failed to comply with a Fair Work Commission direction, or failed to discontinue after reaching a settlement. A number of decisions have come through recently where the applicant has either failed to attend a conference, failed to respond to the Commission when the Commission has contacted them or rung them, failed to file the documents that they were required to file, and therefore the Commission has dismissed their applications without those applications going to a hearing or to arbitration. Another significant change or another significant emphasis of the new provisions is that the Fair Work Commission can order costs against a party and or representative that has caused the other party to incur costs through an unreasonable act or omission. So as it says there, that would include unreasonably failing to settle or discontinue an application. So in circumstances where a reasonable offer of settlement has been made by one party, the other party rejects that offer and continues on to a hearing and ultimately loses or gets a lesser result than the offer that was made to them, then the other party in those circumstances has a better chance of obtaining their costs. And as usual, costs aren't awarded completely. They're usually awarded as a percentage or a proportion of the costs actually incurred. Generally, on a party and party basis, a party will recover about 75% of the costs that they've expended. Then going on to just a note as far as proceedings in the Fair Work Commission as far as unfair dismissals are concerned. The Act now emphasises that there is no automatic right to representation by a lawyer or a paid agent. And a number of applications that have been made to the Fair Work Commission recently have denied representation by a lawyer or a paid agent. That is, the Fair Work Commission has refused permission for the party to be represented by the lawyer or the paid agent. The lawyer or paid agent must show that either the case is of a particular complexity or that the process would be aided by them appearing for either the applicant or the respondent. There is, however, an automatic right to be represented by a lawyer who is an employee or officer of an organisation of which the party is a member, or a bargaining representative. Now that's good news for NECA's members because NECA's members can be represented by a lawyer who is an employee of NECA in an unfair dismissal application or indeed in any other dispute proceedings. Turning then to enterprise agreement, the first point there is that opt-out clauses are invalid, and the case recited there, CFMEU and Queensland Bulk Handling, was a case where an enterprise agreement did have an opt-out clause. That is, that employees could opt out of the agreement and make their own arrangement with the employer, which was in excess of the relevant award. The Act now makes it clear that those opt-out clauses are invalid and cannot be applied in an enterprise agreement. Once a person is covered by an enterprise agreement, they are covered by it, and they cannot withdraw from the current coverage. Secondly, a union official or union cannot act as a bargaining representative for employees who are ineligible to join the union. This would stop union organisers, for example, from offering their services as bargaining representatives to all employees of a particular workplace, regardless of whether those employees are eligible to join that official's union or not. There were, up till recently, a number of enterprise agreements made with a single employee. The changes to the Fair Work Act have now ruled that out. The employer can only make an enterprise agreement with 2 or more employees. Lastly on that slide, the Notice of Employee Representational Rights can only contain the content prescribed by the Fair Work Regulations and no other content. I'm sure you would be aware, or at least those of you that have initiated bargaining or have bargained for an enterprise agreement under the Act, under the Fair Work Act, that the first stage in that bargaining process or that negotiation process is to issue a Notice of Employee Representational Rights. The pro forma notice is contained in the regulations to the Act as a schedule. Previously, an employer could adopt or adapt that schedule, that draft notice, and as long as it contained the required information, then that notice was passable. However, under the Act now, the Notice of Employee Representational Rights must be in the exact form of the schedule. Just going then on to industrial action and protected industrial action. As soon as the slide catches up. Protected industrial action is action that is taken by employees or an employer in support of claims being made during the enterprise agreement negotiation process. For a union to take protected industrial action, it must first of all seek a bargaining order from the Fair Work Commission, and then it must put the proposed industrial action to a vote of its members, and the industrial action can only take place if a majority of the members approve of the proposed industrial action. Whereas previously a show of hands as a vote to confirm that the majority of the employees did approve of the action was permitted, it isn't any longer. It has to be by way of some form of ballot or survey, or as it says there, by way of electronic voting. Often employees who are acting as their own bargaining representatives, even if they were members of the union, were excluded from the vote. The union was only interested in surveying or obtaining conducting a ballot of those employees, those union members that it was representing. That can no longer be done. Self-represented union members do have a right to vote in any such ballot. Now, just going to the changes from the 1st of July 2013 and beyond, in 2013 the Industrial Relations Minister Shorten foreshadowed a number of other amendments to the Act. He made a number of announcements in February and March dealing with parental leave arrangements and protections for pregnant employees, flexible work arrangements, consultation about rostering arrangements, right of entry, and providing access to the Fair Work Commission to resolve bullying complaints. And those amendments were passed by the House of Representatives on the 6th of June this year and became law. The first of the changes, as I indicated in the introduction, dealt with the family-friendly provisions, and these took effect from the 1st of July 2013. in respect to parental leave, parents can now take concurrent leave for up to 8 weeks at any time within the first 12 months following the birth or adoption of the child. That parental leave can be taken in separate periods of at least 2 weeks each, or shorter periods with the agreement of the employer.
I might just interject. We have a question here. I'll unmute and allow the question to be asked. Go ahead, Piero.
Good morning, Piero. Not happening.
My apologies, Piero. If you can hear us, we cannot hear you, so if you could type the question, that would be good. I'll let Gordon continue.
All right, thanks. Before the amendment to the Act, the concurrent leave that could be taken was 3 weeks. That is, that both parents could be off at the same time on parental leave for only 3 weeks, and that was immediately following the birth or adoption of the child. So that's a significant change to that right that was commenced on the 1st of July 2013. Pregnant employees can transfer or have the right to transfer to a safe job at any time, regardless of the length of their service. Previously, that right was only for employees who were eligible to take parental leave or would be eligible to take parental leave from the expected date of birth or date of birth of their child. Unpaid no safe job leave for pregnant employees not entitled to unpaid parental leave if there is no safe job available is a new right for those employees. So employees who produce a doctor's certificate that says that they can continue working but it is unsafe for them to work in the job that they're actually working in have the right to be transferred to a safe job. If the employer cannot find such a safe job for the employee, employees who do not have a right to take parental leave because of the shortness of their service have a right to take unpaid no safe job leave. Those employees that do have a right to take parental leave because they've been employed for 12 months or more, or will be employed for 12 months at the expected date of birth, in those circumstances have a right to take paid safe job leave. Previously, special maternity leave, that is if an employee was totally unfit for work because of the pregnancy, they could take special maternity leave. Previously it was deducted from the unpaid parental leave, that is the 12-month period of unpaid parental leave immediately following the birth of the child. Following these amendments from July 2013, that will no longer be the case. A returning employee will have the right to request flexible working arrangements, and that includes an explicit right to request part-time work. The right to request flexible working arrangements has been extended to the group of employees or the categories of employees that are shown there on the slide. Previously, employees could request flexible working arrangements only if they were responsible for the care and support of a child under school age or a child with a disability under the age of 18. So you can see that the categories of people who can make flexible working arrangement requests has been pretty dramatically extended. And one interesting one is the one there that is an employee who is or is a close family or household member of a person who is experiencing domestic violence can request flexible working arrangements. Now, flexible working arrangements can include things like working part-time, working split hours or reduced hours, working from home, or working partially from home and partially from another venue, for example. The Act says that there must be a nexus between the request and the employee's circumstances. That is, the particular flexible arrangement requested must have some bearing on the reason for making the request, on the employee's or on the particular employee's circumstances. For example, a person who has caring responsibilities may be able to request shorter working hours on particular days to pick their child up from childcare, for example. Now, the employer can only refuse the request on reasonable business grounds. That's always been the case. That was the case before the amendments were made. But the Act now gives guidance on what reasonable business grounds are, and may include the excessive cost of accommodating the request, that there is no capacity to reorganise work arrangements of other employees to accommodate the request, the impracticability of any arrangements that would need to be put in place to accommodate the request, including the need to recruit replacement staff, that there would be significant loss of efficiency or productivity, or that there would be a significant negative impact on customer service. That list is not exhaustive. It only gives a guidance as to what reasonable business grounds may be. Other grounds for refusing a request may be reasonable in the circumstances. Other changes are slated to commence from the 1st of January 2014. The first of those changes deals with dispute resolution and right of entry. The Fair Work Act will require good faith bargaining in greenfields negotiations. A greenfields agreement, as you know, is an agreement that is made by an employer with a union before any of the employees or any employees are employed in the particular project or undertaking that the Greenfields Agreement is intended to cover. And the Fair Work Commission will be able to arbitrate intractable disputes. That's been fairly contentious, and we think that the Fair Work Commission will use that power rather sparingly. Contentious provisions relating to right of entry are those that follow. Union officials will be given access to the lunchroom for discussion with members if the meeting venue at the workplace cannot be agreed. At present, a union official has the right to attend a workplace on 24 hours notice to hold discussions with employees who are members or eligible to be members of the officials' union during non-working time, being a lunchtime usually. The meeting must be held in a place that is designated by the employer and is not unreasonable. That is, the employer can allocate a room, a venue, a part of the site to hold the meeting. From the 1st of January 2014, if there is a dispute about the suitability of the venue provided by the employer, the union official will be given access or can claim access to a place where members of the union or people who are eligible to be members usually take their meals. If there's more than one of those sort of venues, then the employer can designate which of those venues will be the venue for the meeting. Any disputes about that can be referred to the Fair Work Commission, as will any disputes about the next provision, which says that an employer is to provide travel and accommodation for a union official when the union official is visiting a remote work site, and that provision of travel and accommodation must be at a reasonable cost. That is, that the employer can charge a fee for providing that travel or accommodation, but the fee must be reasonable and reasonable in the sense of recovering costs. The Fair Work Commission is to be given greater powers to resolve those right of entry disputes of the type that I've mentioned. This provision has garnered a lot of publicity. That is the provisions dealing with bullying. From the 1st of January 2014, victims of workplace bullying will be able to make a complaint to the Fair Work Commission. And the Fair Work Commission is to list that complaint within 14 days of receiving it. The Fair Work Commission, on hearing the complaint, can make any orders it deems appropriate. However, it cannot make an order for the payment of a pecuniary penalty or monetary compensation. The orders can apply to the employer, or it can apply to the co-workers, that is the persons who are accused of bullying the complainant. Breach of the order, that is if the bullying persists, if the employer does not do the things that they've been ordered to do, or indeed if the co-workers don't do those things, that would give rise to a claim by the aggrieved person for a penalty or damages under a civil remedy provision. That is, they can make an application to a court. The Fair Work Commission will also be given the power to refer bullying incidents to the work health and safety authorities, such as WorkCover in New South Wales, where it believes that the bullying is causing a risk to the health and safety of one or more employees or other people at the workplace. The Safe Work Australia has released a draft code of practice presenting and responding to workplace bullying. That draft code is still, as it says, in draft form and hasn't been finalised. Just continuing on with bullying, under the Act or under the changes to the Fair Work Act, worker will be given the same meaning as in the Work Health and Safety Act 2011. That is, the definition of worker extends to subcontractors, outworkers, work experience students and even volunteers. Any one of those types of worker can make a complaint about being bullied to the Fair Work Commission, and indeed the Fair Work Commission can make orders to binding any one of those types of worker. A definition is included in the new provisions, which says a worker is bullied at work if, while the worker is engaged by a constitutionally covered business, another individual or group of individuals repeatedly behaves unreasonably towards the worker, and that behaviour creates a risk to health and safety, which is pretty much the definition of bullying that has been adopted by all interested agencies. The Act, however, makes it clear, and this has been confirmed by decisions and case law, but the Act in any event makes it clear that reasonable management action is not bullying if it does not victimise or humiliate the worker. So therefore, performance management, disciplinary procedures, performance reviews are not and cannot be bullying if those reviews and procedures are carried out reasonably and do not, in fact, victimise or humiliate the worker. That would be an objective test that would be based on could there be a reasonable belief that the management action did in fact victimise or humiliate. It's not a subjective test. It's not whether the particular worker felt victimised or humiliated. Now, a worker who makes a complaint to the Fair Work Commission about being bullied is not prevented from pursuing other actions. So there's no prohibition against, if you like, double jeopardy. That is, a worker who has been bullied can obtain an order from the Fair Work Commission to stop the bullying, but then can also seek damages in the court or compensation in the court, or pursue an occupational health and safety complaint, perhaps with, for example, with WorkCover. I'll just conclude the presentation and thank you for your attention, just on what's happening with modern awards. Now, I'm sure you're all aware that the national minimum wage increased by 2.6% to $622.20 per week or $16.37 per hour. That is the minimum wage that must be paid to an adult employee other than an employee who is suffering from a disability and is receiving a supported wage, for example. All modern award rates were increased at the same time by the same percentage, that is 2.6%. In regard to particular awards such as the Electrical Electronic Communications Contracting Award 2010, those percentage increases are subject to phasing or transitional rates. The transitional rate has changed from 20% to 20% from 40%. You may recall that when modern awards were made, they contained rates of pay. Persons who had been, or employees who had been covered by a pre-modern award instrument such as the Electrician State Award were paid somewhere between the rate that they were paid under the Electrician's Award and the rate that they were paid or are to be paid under the modern award. That was called the transitional amount. That is the difference between the previous award and the modern award. The transitional amount was either added to the modern award or taken away from it by the percentage that applied at the time. In January 2010, that percentage was 80%. 2011, it was 60%. 2012, it was 40%, and therefore now it's 20%. Those transitional rates affect wage rates, casual loading, shift and weekend penalty holdings. All members of NECA would have received wage rate bulletin number 8 for the Electrical, Electronic and Communications Contracting Award, and also wage rate bulletin number 5 for the Clerks Private Sector Award. Those bulletins contain the appropriate or applicable transitional rates, that is the rates that must be paid in New South Wales for any particular classification. Also from the 1st of January 2010, the superannuation guaranteed charge rate increased to 9.25%. Changes that will be made to modern awards or the effect of modern awards from the 1st of January 2014 include rostering arrangements, and this applies to modern awards and enterprise agreements. The model consultation clause is to be amended to require an employer to genuinely consult with employees about the effects of proposed alterations to rostering arrangements or working hours on employees' family life. The Fair Work Act at the moment contains a model consultation clause, again as a schedule to the regulations. That model consultation clause is to be changed in the way indicated, and it will be the clause that is included in enterprise agreements and the clause that is included in the Fair Work Act. So that means that the employer cannot unilaterally change rosters when the change may adversely have an adverse impact on employees. Consultation must take place, and the employer must listen to the genuine concerns of the employees, such as the effect on their family life, their family responsibilities, the need to care for children at particular times, for example. The new clause will also allow for employees to be represented in those discussions. However, the obligation to consult will not be triggered where an employee has irregular, sporadic or unpredictable working hours. Therefore, it's no need. The consultation clause will not apply in respect to irregular casual employees. Finally, there will be a new modern award objective taking effect from the 1st of January 2014, which says that the Fair Work Commission is to take account of penalty rates, shift work loadings, overtime rates and public holiday rates when setting award rates and conditions. That is, award rates will be affected by the number of employees under that award who typically work shift work, who work more than the 38 ordinary hours per week prescribed by the Act, or who are regularly required to work on weekends and public holidays. That concludes the presentation. If anybody has any questions, I'd only be too happy to attempt to answer them. Piero, have we got Piero there? All right, well, look, thank you again for your attendance this morning. I can see that there are no questions, so, oh, hang on, we've got one question. Oh, sorry, no, there's no question. So I must have done a good job or a particularly bad job. Look, once again, thank you for your attendance, and please stay tuned for the next webinar when that occurs. Thank you.